Hi, Priya.
Hello, sir. Am I audible?
Yes, yes, you're audible. Am I audible now?
Yes. Okay,
So I hope you're
so
doing fine.
yes, sir. I'm doing very fine. How are you?
Uh, I'm doing pretty well. Thank you for asking.
So good evening, everyone. Hope you all are doing well. I welcome you to this live session on the new IT rules that have been enacted, and we have Tarun sir with us. He has secured an All India Rank 1 in ALH LLM of 2017 and is currently a practicing advocate at the Delhi High Court. Sir will be analyzing the IT rules with us. I welcome you, sir.
Priya, I cannot hear you. Hello?
So can you hear me now?
Priya, am I audible? I cannot hear you.
So am I audible now?
Yeah, you're audible. Am I not audible?
No, Mr. You are audible.
Right.
Okay, so first I would like to begin with the gist of the IT rules that goes by the Information Technology Guidelines for Intermediaries and Digital Media Ethics Code rules. We will be discussing the key points and the concerns raised by them. So, sir, what would you like to say about the rules and the concerns that are being raised currently?
Well, Priya, see, before delving onto the gist or in any form of any type of rule or anything, I would rather say I would like to start with the act itself because it's the act from where the rules are being derived. And in order to ascertain or to see what exactly has happened or been in the mind of legislature while they enacted this law, we'll go to the preamble. Now, if you look at the preamble of IT Act, what it says is this act was solely made with one focus in mind to give legitimacy to the e-transaction, be it e-commerce transaction or the transaction that we people have on a regular basis on mediums like Facebook, WhatsApp, Instagram, and so on and so forth. And the second part was to legitimize the evidence, which are some things are stored in e-form in order to make them legitimate evidence in the court of law. This was the only thing in mind of the legislature which I can decipher from the preamble, because of which this entire IT Act was created. And even if you read the act in its entirety, you'll understand the entire act is based on these things only. Besides the fact that there are few offenses which are mentioned there, but then those offenses are like regarding to sexual explicit content, some defamatory content which has been published online. So they are fairly reasonable ones. Otherwise, the major role that this act plays is of legitimizing a transaction, legitimizing some evidence for a court of law, and providing for the ways in which these transactions can be carried out safely. And in this act also, there is also, though in the hindsight, but there are few provisions which actually take care of privacy because these provisions say that these players, if I may, because the right term to use will be intermediaries, but these rules now they have demarcated this factor, so I'll come on to them later. So where we put our information or whoever collects our data, they are duty bound to protect that data according to the act. Because I know a lot of people who have joined, they must all be thinking that, and they must be coming from a pre bias, the okay, these rules are bad and not. But I'm just clarifying something that the act in itself says something contrary to the rules. The act says intermediaries or any kind of third party who collects our data or anything which could be categorized into sensitive information, non-sensitive information. Now, what that difference is, that is nowhere defined, neither here nor there. But anyways, any entity, be it a body corporate, be it some other source where we put our information in, which works on an electronic basis, right? Whenever it collects our data, that entity is duty bound to safeguard our data and protect it and not to leak it. Now, with that background, now I'll come to the rules because we only have 1 hour, so not delve much into the act. But I'll definitely correlate both the things in order to make sure that things get easily understood. Because when I was researching on these things, and I've been researching like I guess December 2020 on these rules, so what I found was, especially after the enactment of these rules, a lot of things are being said, have already been said, they are still being said, and all of them have one thing in common, that is these rules are draconian in nature. These rules take away the rights, of any individual, and somewhere they're right, but then there is more to what meets the eye, because nobody is talking about something which I'm going to talk today. Now, some people might not agree with it, but I'll try my level best to showcase those kind of things as well, which are there in the rules. Now, first things first, when we see any kind of delegated legislation, because the rules come under the definition of delegated legislation. So whenever you read delegated legislation, you need to understand from where are they deriving its power, from where the authority which has made these rules, where did they derive their power, and which becomes very clear when we read these rules in the very beginning, in the Gazette notification I'm reading. It says that the authority derived its power from subsection 1, section 2, subsection 1, clause Z and clause ZG of ITI. And when you read, I'll just go to these things. I'll not read it like verbatim, but I'll just see. So this subsection Z of section 2 says that the government, or the basically it's the section says the central government can make rules, obviously, therefore the rules are there, for the procedure and safeguards for blocking for access for public under subsection 692. Basically, these rules are meant to lay down the criteria, some procedures, some guidelines to make things easier as to when a content will be blocked and how it will be blocked, which authority will block it. So the purpose is to give only the guidelines. That's it. That's it. We can get this, the authority which was delegated for this, that you devise some guidelines, some parameters which will give some clarity as to which content will be blocked and why, and what will be the authority. And second part was this ZG, that is the guidelines to be observed by intermediary. So in short and simple words, the power that was given to the central government to form these rules was to lay down certain guidelines, to tell the people, or to whomever the players are, as to what content will be blocked, why it will be blocked, by which authority will be blocked. Second, about intermediaries, as to how should they operate and what should they do. That's it. Nothing more, nothing less. That means the power was also not absolute. Like, even though this has been settled way back in 1984, that whenever a delegated legislation is made, the framers, they have to work in the four corners of the parent act. In this case, this has not been followed. And that's my frank opinion. That's my analysis. Somebody might differ from it. And till the time no court ruling comes into it, because right now some petitions are also pending. They were there in the High Court. Now they've been sent to Supreme Court. Unless until some kind of, it's only going to be my opinion. So I'm just being very cautious and saying it's my opinion. These rules have breached their ambit, which was given to the authority. And I'll come to it later. Because as I'll go ahead, I'll try to create a nexus that will make it more clear as to why I'm saying whatever I'm saying. Now, after understanding this gist, should I start as to why whatever I said, should I start explaining it? Priya?
Yes, sir. Please go ahead.
Right. So see, now again, like I said, first things first, I'll start with the act. Because the rules are something that comes from the act. And let's start with the act. What does the act say? If you look at section 43A of the act, now that says that any intermediary or any party, let's say any third party or any organization which works on the e-platform, whomever works there, collects our data, has a duty to protect it, safeguard it, using the safest means they can. And if they fail to do it, they will be held liable for compensation. Correct? Now the act says that the intermediary, or whomever is the, I'm going to clarify it later. Now, right now I'm using the word intermediary. Let's say there's an intermediary. So he's duty bound under the act to safeguard the information. Because the act says it. Act is the law of the land, not the rules as of now. The act is. And if they fail to do it, then they'll be liable for compensation. And not just compensation, they'll be liable for penalties as well under the act. Because if you just give me a second. Right. So besides this compensation, they'll be open to criminal prosecution as well under the act. There go, intermediaries are duty bound. The act says. Second thing, the act also says that any intermediary who stores data has to make sure that their process and that their computer resource, that means their software, is so secure, at least according to their own resources at hand, it cannot be breached by others. Therefore, WhatsApp uses end-to-end encryption. So does some other apps as well. Just an example as of now. As of now, these entities, they were operating in India, they were complying with these rules, and therefore we saw this coming of end-to-end encryption, because WhatsApp, Signal, whatever you want to use, they were not end-to-end encrypted since very beginning. They started doing it only after the onset of these laws, and as and when they started getting into enforce. So they did that. Right now, everything is encrypted. Then comes another thing. Then Act also says, कि, look, if this intermediary has done something, some work to safeguard the data that it is taking from the people, then the company will, then the intermediary will make sure that they either knowingly or intentionally neither don't do themselves, or nor can they abate anyone which can breach their software and take this data. Basically, nobody can leak that data. Second thing, if somebody leaks that data, then they will be open for criminal prosecution. That also the act says, and that punishment is given in section 65 of the act. So basically, in short, as far as the intermediaries are concerned, the legislature says, look, you want to work in this country, you work. For us, the privacy of our citizens are the utmost. Now that we also have the judgment as well. So you have got to safeguard it. Companies started doing it. They were doing it, and now they did it something more than that. Then comes another section which says the companies will preserve some data of their clients for a specific period of time, which was earlier for 3 months. Now, from by the rules, has been made to 6 months. But what data will be stored? There was nothing clarity as to what will be stored. But as far as the practice is there in the entire world, some metadata used to be stored. Now, I'm sure everyone must be remembering when WhatsApp updated its privacy policy earlier this year, there was a huge hue and cry about this thing. And I'm pretty sure more than 70% of the people did not even read what their privacy policy was. But everybody was showing his or her outrage that I'm going to switch to some other app. I'm not going to use WhatsApp for any reason, this and that, without even knowing what it is. Whereas the simple modification that they made in their policy was that now they're going to collect the metadata, that too of a very specific nature, as in this metadata that you provide them. That means when you when you use Facebook, say I'll not with WhatsApp, these are not the things, but when you use Facebook, there are certain ads on the site. That's where Facebook earns their revenue. But in those ads, it is clearly mentioned whether it's sponsored or whether it's something, it is clearly mentioned. It is only when we choose to click on that, the Facebook gets some data, that metadata, and Facebook collects it and stores it and then shows us ads which are relevant to that thing. It's called target market advertising. There's nothing wrong with it. Facebook has been doing it from very long. So was Google. But the point is, WhatsApp came forward and showed it to the public, and public didn't like it without even understanding that this has been happening all along. And there's nothing wrong with it because they're only storing some metadata. Now that I've told you about, and I gave you this example in the very beginning so that you remember this thing. Now I'm going to come to the main point. Now what happens is, having this in the act, in the main law, now come the rules. Now what does the rules say? The rules say that now we are going to categorize intermediaries. They come to they come down to news reporters. Basically, not news reporter, but you can say somebody who runs a channel, who runs a blog, who runs a portal, anything, who provides news on the e-platform, be it in a written form, be it in a visual form, whatever it is. But we have to note one thing, like I read the preamble in the very beginning, the act does not talk about them. The act simply does not talk about e-news, e-media, or in fact, OTT operators as well. Nothing. There's nothing at all in that. But somehow, when the rules came into the picture, they talk about it. Now they have very clear-cut guidelines for them. Why? From where is it coming? According to me, it's not legal. They have breached their scope. But as far as intermediaries are concerned, Now, what the central government says? The central government says, okay, look, now if you want to work in India, you have to modify few things. You have to change your entire software in order to you can comply with our terms. Now, what terms are they talking about? First of all, in the parent statute, in the act, they say that you have got to make your software so strong that nobody can hack it. Like at least make it that strong that you have the capability of. And now they're saying if you want to work here, you've got to break the system. The act says nobody can change this software, the computer resource, even the program code for that matter. Nobody can change it. If somebody changes it, knowingly or intentionally, he will be punished. And the act does not start with a non-obstante clause. The act does not say, nowhere does it stipulate, ki, look, only in certain circumstances you can do it, or in these circumstances you cannot do it. The act simply says, anyone who contravenes this thing, who changes the software, who lowers the privacy protection of privacy, he will be punished. Now government comes in and says, look, you want to work? Now we have changed the game rules of the game. You have to abide by them. And what you have to do is, as far as messaging services are concerned, like WhatsApp, Telegram, Signal, they have to enable the first originator. And we all know, I'm sure everybody must be aware of that as to what that thing is. But I'll explain a little better. This thing of first tracing of first originator, that means these systems, these applications, they'll have to remove their encryption. And in order to understand why this is bad, I'll just try to give you an example. See, I'm not an IT guy, but with my limited knowledge, I'll try to explain something. How this encryption works. Encryption works on a hash technology. What happens is, even if let's say I text hi to someone, that hi will get converted into a 14-digit code. Now, WhatsApp stores that 14-digit code. Yes, no doubt about it. And then it transmits it to the person that I'm transmitting to. That person has a private key, which then decrypts the message. So basically, encryption is a technology which does not go backward. But when you combine encryption and decryption, that's how WhatsApp works. In order to see the message, you need to have both the things. That is private and public key. But in terms of no encryption, you don't need anything. So now what happens is, see, I give you the example of WhatsApp. People were all over the internet. There was huge outcry. They were collecting our data, but they were only collecting the metadata. Now with these guidelines in picture, WhatsApp will have to collect all the data. Platforms like WhatsApp, they'll have to remove their encryption. They'll have to store literally each and everything we type and we send to someone. They will have to take it. They'll have to store it and see why this is bad is, first, our privacy is being breached. Whatever, if I want to speak something with you, if I want to text something to you, I want it to be personal. Therefore, I'm texting only between you and me. But now the WhatsApp will have it. Now what will happen? We know whenever we store something in mass quantity, what will happen? Slippages, leakages are bound to happen. They are bound to happen and they will happen. Now what will happen if WhatsApp starts storing all our messages, everything, entire data, and believe you me, WhatsApp has recently started this payment methods. If this encryption goes, a lot of people who are using WhatsApp payments, their banking accounts information will also get leaked. And we all know how phishing works. We all know what kind of scams are running in the country. Despite we having such kind of security, let's just think what's going to happen after that. But these rules say you have got to remove encryption. You've got to store everything. Why? So that whenever the government agency, whatever agency, no definition, anything, but whenever some agency calls you, ki, look, we want this data for this person, or either you find the first person from where this message originated, then you'll have to run it from the system. You'll have to do something about it. You have to collect the data. Now, let's say from your team only, somebody leaks the data. What will happen? From WhatsApp's team, somebody leaks the data. Where will we go? These laws, these rules does not make any special code. What will happen then? Despite having such kind of encryption, we are still losing our privacy. Every now and then we have cases coming in the news or in the court of law, like something is happening. I've been fished. My account has been cleared. Things are happening. Once encryption goes, what will happen? these rules, I'm not going to read everything, but the major crux where the problem is this: number one, now they are being forced to store all the data that their users use. And by the way, a lot of people were saying that we'll switch to Signal. Signal is much better than WhatsApp. I'll tell those people, Signal is the one which provides software everything to WhatsApp. So when we use WhatsApp, we use the software of Signal only. So there's actually not much difference. And if WhatsApp someday, let's say, in order to comply with these regulations, now though they have to comply with these regulations, but if government does not do anything and WhatsApp decide to, let's say, remove encryption, then so does Signal. In India, Signal will also have to abide by them. And the worst cases, these rules say, now, see, I'm not going by the because we have very limited time, so I'm not reading them. I'm trying to explain in the short form. I hope the readers are liking it. But so what I was saying was, this government now has made it clear to the WhatsApp, कि, look, we are not even asking you to store data of Indian people. Rather, you have got to store the data of people all over the world because we want you to give us information who is the first originator. Now, what does that mean? First originator can be anywhere in the world, can be using server anywhere in the world. And we already have more than 350 million users in India. Just imagine how much of a bigger user base they have all over the world. And if WhatsApp starts storing all these messages, it might comply with the rules in India. What about outside? And that too, in the backdrop when we don't have any kind of data protection law. Now, what is happening? When these entities they try to stand up to the government, look, please do something about it, change this thing, because the act says you have got to secure it. If you do not secure it, you'll be liable to prosecution. If you have secured it already and you change your software, then again you'll be liable to prosecution. And now the government say you have to change it. So these intermediaries are now at mercy of government. If they do something, they'll be prosecuted. If they don't do something, they'll be forced to shut their business down. Now what will they do? And the worst part is they cannot even go to court because in these so-called rules, suddenly a three-tier mechanism have been given in the form of some code where these intermediaries have to first of all appoint few people in their own organization, which by the way are should be Indian resident. Now keep in mind, all these business models, they are asset light models. There is a reason we get to access them for free. There is a reason they can provide their services for free to us for the rest of our lives. Why? See, they earn revenue from ads. That's fine. Every business is there out to make profit. But then there's a reason because they don't incur much cost. It's the asset light model. They are only dependent on servers. But if they are forced to open their offices in India, right, and that will not just in India, what will happen then? It will add to their cost. At the same time, they'll have to appoint these key managing personnel, the CCO, the CFO. I'll come to them later. All of Indian resident. As of now, up until now, before these rules, these people were still there. But somewhere, some softwares were using bot technologies. If you go to their websites, there's always a pop-up that pops out, key, we are here to help you, whatever it is, or you can raise a ticket. That will reduce their cost. But what is happening right now? They are being forced to increase their cost. At the same time, decrease the privacy of their users. What the government will do? And also, the government has made it legal now that any person, let's say, I'm someone in, I hold some position in government, correct? Now I coerce, or let's say I threaten these WhatsApp people. Okay, look, I need Priya's information, so you store it, right? And because you're storing everyone's, na, so you store this particular woman's data and you give it to me. So long as WhatsApp is storing your data, WhatsApp is fine. The moment it gives that data to me, then they will be liable for punishment under the act. So why do you want something to be collected if you have made the transmission of that data as an offense? I fail to see any kind of logic in that. For me, these no none of these rules make any kind of sense. I don't know. I just read it and I feel like what is happening in this? And on top of that, you make rules where you say, or in fact, earlier where the rules were, in fact, if you take a phone interception, right? Even in phone interception laws, there is proper written laws, which in this case are not. Only the rules are there. What they do is they does not allow telecom operators to record data or hand over data to anyone. For that matter, these telecom operators will not even give me your data. Even if I ask them, look, I need this subscriber's data, they'll not give it to me, not even to police, unless they have a court order. Right now, what's going to happen is this government does not need a court order. What they need is simple a government's response, a designated authority from the central government only. Somebody's order that you give me this person's information, everything, and they'll do it. The point is, if that was the intent behind it, I understand this cybersecurity is a very big thing. I understand cyber terrorism. See, WhatsApp already stores our messages in the form of binary codes. Like I said, how encryption works. When we write something, it gets transmitted into a 14-digit binary code, and that binary code is stored with WhatsApp for 3 months. Now it's for 6 months. Till the time you can increase the time limit. Okay, look, you are collecting these binary codes, na? So you collect these binary codes, you store them for 6 months, for 12 months, whatever it is. If let's say I'm the government or something, I'm some agency, I'm from CBI, and I need some information. I think that's XYZ is guy who's trying to plan some terrorist activity. I need information about that guy. I'll simply have to contact the nodal person at WhatsApp and I'll look, give this XYZ information, right? What that XYZ will do is XYZ will provide me the codes that it has saved. And trust me, though those codes are very hard to crack for a layman, but they're not that hard to crack because there is a thing called Rambo table. Now, what happens in the Rambo table is actually a table created by all the hackers around the world. What these hackers do is they have collected all these codes. See, because if I've written, let's say hi, right, and hi is translated to 1 2 3 4 5 6 7 8 9 10 till 14. So even if you write hi to someone, it will get converted to same 14-digit number. So if I say I'm fine, that will get converted into some other 14-digit number. That's how they have made a Rambo table of these codes. So for government, they already have access to these kind of things. They can ask WhatsApp, okay, look, give me this information, give me those codes, store those codes, give us those codes, we'll intercept it, we'll decrypt it, we'll do whatever we want to. And WhatsApp will be more than happy to do it. WhatsApp does that throughout the world. That's how, not just WhatsApp, every intermediary for that matter, they are very proactive in helping the government agency, but not at the cost of the privacy of the clients. But I don't know, this government is trying to do what, I have no idea, because see, they have already controlled media. And if you ask from my personal opinion, these rules are nothing but a validation to censorship, not just to news or any kind, but also to intermediaries. Now they want to have a look, a watch at everywhere. And I was understanding till the point that they said, okay, fine, we want to, national interest is the utmost. I get it. I understand national interest is the utmost interest. We have to take care of it. But then why do you want a quarterly meeting with these intermediaries as to what exactly is happening in their business? Why do you want to snoop your nose into it? And then comes the worst part, these ODDs and news sharing centers. Nowhere covered in the act. Nowhere even there in the intent of legislature when the act was made. They are not being regulated by TV, news, press act, the different acts which govern the print media or the TV, cable TV. There are different acts, but at least they are codified laws which governs these kind of mediums. As far as internet e-medium is concerned, there are no laws. These rules, according to my legal acumen, are nothing more than a paper to be printed on. They are ultra virus as far as my legal argument goes, because that these rules, when they demarcated, when they started getting into a sphere which was not even marketed to them, was something makes it ultra virus. And I feel we'll get that judgment very soon. But let's not go that into the. And the third point that you told me was about this hate speech and what will happen, right? So, like I was saying, these rules once at one side they have mandated to store all the data and then give it to government whenever they want to remove their encryption. That one thing. Second point for intermediaries, what they have done is now these intermediaries will have to appoint certain people who are of Indian residents, such as chief compliance officer, chief nodal officer, so on and so forth. Now, what we are seeing lately is all these intermediaries, they are meddling with government, not meddling, but they are locking horns with government, or you can say the other way around, government is locking horns with them, not because they have not removed the encryption, not because they are not following any of the rules, but because they have failed in appointing a chief compliance officer. And the reason for that is these rules say if any intermediary does not follow the rules, does not comply with the guidelines, the chief compliance officer will be the one who will be held responsible for it. Because of the fear of being held responsible, and we know how these things work in this country for these things, nobody is willing to take that post. Correct? Now, I would like to point out something that despite the rules being saying that, such and such person or such and person of this designation will be held responsible, the Act, Section 85 of the Act says if a body corporate is the one which commits some offense or maybe does not comply with anything, then the person responsible will be the one who is in charge, like any other law. Because all these intermediaries they work in the form of a body corporate only. They don't work like a sole proprietorship or anything. So their liability, the CCO will not be held. Now the point is either he'll not be held responsible, or if he'll be the one who's held responsible, then who is going to showcase? Look, I took all the caution. I was not the one who did all this wrong. So why are you prosecuting me? Government is saying, look, CCO will be held responsible if the compliance list is not followed. In order to follow the compliance list, a lot of things I need to be done, major of which I just told right now. But the act says if a violation happens, the person in charge of responsible to heard of being heard, and also if he can put forth a defense, then he'll not be held responsible. Then what is it? Now is there no not ambiguity? But people out of fear are actually not taking that post, and that's why government time and again is now threatening them. Look, we are going to ban you. We're going to remove you from our country. We're going to do something and whatnot. But the point is, when you have made these rules, which are not in consonance with the act, what do you expect from them? They just need some kind of scapegoat to do something about it. And this thing, like if to I today, let's say, go on to some intermediate platform and write some hate speech about anything. Now, the point is, who is going to categorize it's a hate speech? Do we have a criteria for it? No. In order to have any kind of fetters on anything, especially in form of what we write on an intermediate platform, on any platform, whatever a news agency is printing, there are certain factors, and all factors are still somewhat clear, barring one, that is if that content harms public order. Now, what exactly is public order? Can you say what is public order? Can I say what is public order? No. But if the government doesn't like it, government will say no, this content is in contravention with public order, it will harm the public order, so we'll just ban it, or will not make it showcase it. Basically, what they are doing is, as far as these new OTT centers are there, they have indirectly made it somewhat mandatory for these OTT players and also these directors and the screenplay writers to show their script to the government in advance. That does not even happen in term with CBFC, and we know that's the biggest agency that gives certification to the movies, right? There also this doesn't happen, but indirectly these rules say, okay, look, in order for us to, because they are the one, they have eliminated judiciary from these rules, from this act everywhere. What they have done is they have given executive the power to judge as well. So what they have said is, look, if Priya wants to write a screenplay, wants to direct a play or a series or anything, which will be let's say, will be hosted on Netflix, Amazon, or any OTT platform. You will have to tell me from very beginning, okay, sir, this is the script. These are going to be my players. This is what it's going to be. You have to showcase that. Now, let's say you came to me and you showcase that to me, right? What is the guarantee that nobody from my office will not leak it? Once you came to me with genuine intent, okay, look, if I'll give you a green signal, okay, fine, it will not be held against public order, then only you will invest something in it. Because the producer will not put money unless until he knows that these series are not going to be banned. You have the pressure of producer as well. The producer is saying, I'm not going to pay you money. Please get some clarification. You have put in your hard efforts. Now somebody from my office leaks that information. That screenplay. What will happen? We all know once these kind of things happen, it's like the genie is out of the bottle. And then good luck putting back in the bottle. It's not going to do. You will lose everything. What's the point? So much of ambiguity, so much of power in the hands of executive, so much so that they have breached the walls under which they had to work, and they came up with these rules. Well, I don't know what else to say, but as far as my views are concerned, these rules should be held ultra vires. Let's see what the court says. See, it's just my opinion. I'm again repeating, it's my opinion. I don't want any kind of strike to be happen on me, at least, or on your channel because of me. We are also communicating on e-medium only. Is there anything else you want to ask from these rules?
No, sir, I think I'm done. Now we can invite questions from those who are attending the session. Guys, if you want to ask questions, you can just post it in the comment section and we'll be addressed also.
Right, and I'll just clarify again. See, I did not explain all the rules. I just talk about the most contentious rules which are there. So if anyone has any kind of question with respect to that or anything for that matter, we'll take it. Okay, I read one question on the screen that some dip toxic.01. I don't know if I'm pronouncing it the right way, but the name is such, it's going to pronounce that way. Executive adjudication is not something new. They are in multiple acts, including civil tenancy act. I don't know what that guy or girl's name is. The problem, my dear, is in tenancy laws, your privacy is not at risk. And when I say your privacy, I mean the privacy of entire nation. Those disputes are between few people or two people, maybe landlord or tenants. And what you're referring to are disputes which then goes to quasi-judicial bodies for the adjudication, not to the executive, but quasi-judicial bodies. In this case, there is not even a quasi-judicial body. And at the same time, these rules also say that they can actually put a ban on any content if they feel it that urgent without even giving any kind of opportunity for the creator of that content to be heard. And also, I understand if there would have been one provision which say, look, in urgent situations, the government can ban it. But like in the case of preventive detention laws, because of urgency, you cut down something, you ban something, right? Or you just remove it from the platform, but only for a limited period of time. And after that period of time, you hear other person as well as to what exactly he wants to say, and then take a decision. In this situation, that is also not the case. What is being said is the government can ban any show from these OTT platforms. Anything. They can censor anything they want if they feel it's urgent. And what is urgent? Nowhere mentioned. What affects sovereignty of India? Anything can affect. Once again, public order. They felt something that is going to affect public order. Let's ban it. We are all aware of a lot of series being blocked, never being aired. Just think how much of loss those producers, those actors would have been taken. Never being aired. Why? Because of public order. Now, who will be the judge of it? The executive. These people who handles the board. Because neither they hear from the content maker, they just take a decision, and after a decision, they send it to a committee. That committee is also made of executive members only. And even there, they did not hear the person. There is no right of that person to be heard. They have to, and then that committee will take a decision unanimously on their own, and then they'll just go ahead with it. If they think, okay, fine, they have been rightly blocked, just block it. If not rightly blocked, then fine, unblock it. But in that duration, where are you giving that other person a fair chance to be heard? You're not. At the same time, you have created three levels of I don't know, imaginary levels, I guess, of adjudication. What adjudication? These are executive adjudications. You cannot even move to court. See, not indirectly, they have also taken away the right to approach the court. Why? If there is anything, let's say you have some kind of problem, what you will do is you will go to that intermediary, whomever the concerned person is, you will tell your grievance to that person. That person might or might not solve it. Anyways, if your privacy at risk, you can go to court. You can file. As of now, abhi tak, you could have done something about it. Now, what will happen is you will have to go to the concerned person of that intermediary. Number one, if your issue does not get fulfilled, then you will have to move to another thing. But the point is, even in urgent situation, you cannot even move to a court of law. You cannot even move to a writ court. Why? They did not they did not take away the opportunity of you to approach a writ court. But I'm telling you from a practical standpoint, our writ courts are very slow in entertaining any writ in the ambiguity sets in. What is an equally efficacious remedy? But then these courts will see, कि, look, if not in the act, in the rules, there is a way, there is authority, there is a board you can go to. So just go there and then you challenge that action. What will happen? If somebody's show has been banned for no rhyme or reason under the garb that it was felt necessary to do that, it was urgent. Where will the poor guy go? Because he has invested everything that he has into that show. He cannot even go to the executive board because there also he does not have any right to say. And what will happen if the executive board does not give any kind of reasoning in the time bound manner? What will happen? We all know even those movies which were already finalized, not just finalized, were given green signal to be aired. Yet, just a day before the release, they were released on torrent. They were leaked everywhere. Just think about the fate of these series which are all set to go on air. They are already in the hands of some people. Now they are being blocked. Where will they go? By the time their adjudication will come, by the time they'll get the right to go to court, they lose everything. So, my dear friend, this is very difficult. Is there anything else?
I have a question to ask, like we were discussing about hate speech and so if
Sorry, Priya, I cannot hear you.
so can you hear me now?
Yes, it's better now.
Yeah. I was talking about hate speech and if anyone shares offensive content on any social media platform, and in an imaginary situation, if it leads to unlawful assembly or rioting, and in a case people are killed in that case. So, how will we outweigh the right of privacy of the user who has shared the content and the right to life of people who are killed? In that case, since right to privacy is a subset of right to life, so in that case, we'll have to like give importance to the core fundamental rights, right?
Sure, very good. See, I'll tell you. First of all, since these rules are applicable to our community, our society, like in India, so I'll take that frame in mind. Lately, our society has come to a point where literally anything can spark a controversy, which can get violent in like spur of the moment. Correct? Therefore, I said, who is going to judge what exactly is going to affect the public order? And whenever some disputed questions of fact arise, what is the agency that answers that? It's a court of law, not an executive. Even in preventive detention cases, executive takes an action and then the courts are there to adjudicate upon them. Correct? Similarly, in this case, let's say today, for example, I go on my Facebook profile and I write that when this COVID pandemic started, there was an incident of Tablighi Jamaat. correct? That Jamaat was associated with a specific religion. That religion and the people of that Jamaat were targeted and targeted so brutally. Why? Because they were called as carriers and they were called the major reason of spread of this pandemic in entire Delhi, entire India. That was to that extent it happened. Today I go and write, कि, look, everybody criticized Tablighi Jamaat. Let's say this is the time when Kumbh is happening, and I write, and nobody is giving and paying any kind of attention to this Kumbh, which is way worse than that. That's my opinion, right? I have a right to say that because I have the mind, I have my brains to form an opinion based on certain facts. But the opinion I formed, I just wrote it down. What happens after that? Let's say in UP or in some parts of UP or not in UP, let's say in MP. Now, that specific religion to which Tablighi Jamaat belonged, now they start getting violent with Hindu. Why? Because earlier you blamed our religion and people of our religion, and now look, your people are doing worse, and your government is not doing something. Now, was it because of me? They can say, "Ki, look, that guy also wrote it. So that hurt my sentiment. That got me all enraged. Yes, he is very right. Nobody gave a fuck about us, and they just tortured us like anything. Now we'll also do the same thing. Do I have anything to do with it? Does my post, do you think, will it fall in that ambit of ruining the public order? I'm sitting in Delhi, and these things are happening in MP. They are taking my statement as a ground. Can police arrest me now? Can they prosecute me for this? On one hand, prosecution will say, yes, we can. They are taking your statement as an example. But in my defense, I will say, look, I'm an educated person. I formed an opinion. What is the importance of getting educated or education if I cannot use it to form an opinion, that too in a democracy? Correct. See, there is a fine line. I get it. There's a fine line. But then who will demarcate it? From where will we get? There has to be certain guidelines on it in order for that kind of demarcation to be made. There is nothing. But with these new rules, anyone who does anything can be caught, can be pulled up, can be tortured for anything. Anyone's account can be closed. Our data is going to leak, and we cannot do anything about it. And we all know what happened with the Pegasus incident just recently. We don't even know the amount or maybe the kind of repercussion we're going to see, the kind of fight back. I don't know if fight back is going to come or not. But the point is that is also very scary. Just imagine if somebody can hear whatever you say without your phone being on. That is where that is happening where you're not even aware somebody is listening. But see, when you are texting somebody and your texts are being shown on a television to others, this does not sound fair to me, at least.
If we can wait a minute or two more for the questions if we have any. And then I think we don't have any more questions. Thank you, sir. Thank you so much for joining this session and addressing our followers. And thank you, everyone, for joining. This live session will be accessible on our Instagram channel and will be uploaded in YouTube in a while for your future access. And you can always reach out to sir. We'll be tagging him in the post. So, thank you so much. Have a great day, everyone.
Thank you, Priya.